How many shares do you need to control a company? Not 51%, not 50% plus 1 share. You only need 33% plus 1 share to gain control of a company. To understand the takeover offer in stock market as a retail investor, for example, why sometimes it is voluntary offer, sometimes it is mandatory offer, unconditional, conditional, why sometimes I got compensated automatically and sometimes I didn't. To understand all this, you must first know the takeover code. Hi everyone, I'm Mr. Dev from The Modern Reminder. Welcome to Beyond the Ticker Tape, where we dive deeper into the market and price fluctuation with investment insights that last. Today we are going to talk about a boring topic, takeover. It is so boring that sometimes even some industry veterans don't bother learning about it. To be clear, we will only talk about the takeover business in relation to retail investor in the jurisdiction of Malaysia. There are rules in place to make sure the takeover process is fair and transparent for everyone. The rules are called Malaysian Codes on Takeover and Mergers 2016, or Takeover Code for short. You may think that I'm being sarcastic here because as a retail investor, you never really felt being protected when it comes to takeover offer. On some level, that is true. Until today, I still cannot fathom the expression from independent advisors advising the shareholder to take the deal, even though it is not fair but reasonable. Yet, these rules are not useless. Thinking that they are useless is just as naive as thinking the police forces are useless because some of them are corrupt or inefficient. Imagine a world with complete absence of such rules and systems, it can be way worse. You see, as retail investors, we don't have control over the company, so it is essential for us to know if there's any potential changes in control. To understand the takeover code, you can start with this chart. The first threshold is 5%. When a person acquires more than 5% of a public listed company voting share, that person is considered as a substantial shareholder. He or she must publicly disclose his position within 5 market days. This disclosure will keep the person on our radar, but he or she is not required to make the takeover offer yet. In fact, from 0% to 33%, one can make the takeover offer, but is not obligated to do so. This is when you see a voluntary takeover offer. It means that the offeror is making the offer voluntarily, and since it is done voluntarily, the offeror has more flexibility in the price and conditions. But once the holding crosses the 33% threshold, that is 33% plus 1 share, the offer becomes mandatory. Why? According to CMSA section 216, owning more than a 33% share in a company grant you the control in the company. How so? With more than 33% share, one can elect the director to represent it on the board. One can also grant a blocking minority position, meaning that the shareholder can single-handedly prevent certain decisions require supermajority, like a change in the company constitution or changes in control. It doesn't guarantee outright control but gives substantial influence. Imagine a company as a car. A 33% plus 1 share is like having a powerful veto button that can stop the car from going in certain direction. You don't necessarily have the steering wheel yet. With this kind of power, one can squeeze out the minority shareholders slowly without them realizing. That is why when one acquires more than 33% shares, that person is required by law to make the mandatory offer. This is when you see a mandatory offer. It means that the offeror is mandatory to make the offer. It doesn't mean that you are mandatory to accept it. Mandatory offers are subject to stricter regulation than the voluntary offer. The price must be or is supposed to be fair and equal to all shareholders, and the offeror must comply with specific timelines and procedures. You should see this 33% plus 1 share as a rule of thumb. It applies to most of the mandatory offer, but the threshold can be lower because the Securities Commission, the regulators, has the discretion to do that. Now you already have an idea of what is voluntary offer, what is mandatory offer. In either case, the offer can be unconditional or conditional. For unconditional offer, when the offeror makes you the offer and you accept the offer, the deal is done, full stop. As for conditional, the offers is only binding when certain predefined conditions are met. These conditions can be regulatory approval, financing arrangement, due diligence, minimum acceptance level. The last one is very common. You can always see something like the offer becomes unconditional upon achieving 50% share in total. It means that even if you accept the offer is only binding when the offeror achieves more than 50% shares in total. You may notice that sometimes even after the takeover offer, the share price doesn't jump up to match the takeover price. This is usually the reason because the offer is conditional and the market doesn't think that this condition can be achieved easily, so they are giving a discount to the takeover price. Now, what happens when it crosses a 50% threshold? Saying it is still a mandatory offer. Remember, as long as it crosses the 33% threshold, it triggers the mandatory offer. It is just that sometimes one doesn't go through the slow accumulation of shares. For example, by acquiring a huge position through a direct deal, and then you see the shareholding jump from 10% to say 55%. In that case, it is still a mandatory offer. The only difference is that with more than 50% share, it is called statutory control. Using the car analogy, now you are controlling the steering wheel. And usually at this stage, the offer becomes unconditional. Here's the important thing. Regardless it is conditional, unconditional, voluntary, mandatory, you always have the right to turn down the offer. Whether or not you should take the offer, it depends on what you think of the takeover price in comparison to the intrinsic value of the target company. Unfortunately, many retail investors feel that they are being cornered to accept the offer because of this statement. The offeror doesn't intend to maintain the listing status of the share. Let us look into it. The Bursa listing requirement states that the listed issuer must maintain at least 25% of its total share in the hand of the public. If the takeover offer results in the offeror holding less than 75% of the shares, then it will stay listed. There's nothing to worry about. However, if it results in more than 75% but less than 90%, then you have to see whether the offeror has the intention to maintain the listing status of the share. Scenario 1, if there's intention to do so, the offeror will work with the target company to explore various options and proposals to rectify the 25% shortfall within 3 months from the closing date. Even if it can't be rectified in 3 months, it can usually be extended. Scenario 2, if there's no intention to maintain the listing status, the offeror may request the target company to make the necessary application to withdraw the listing status. However, this is subject to the shareholders and Bursa approval, so it will be a lengthy process. So you can see that in either case, you will still have plenty of time to observe and to get out if necessary. If the takeover offer results in 90% or more shares being held by the offerer, Bursa Securities shall suspend the trading of the shares after 5 market days from the closing date. At the time of making this video, Bauxite Plantation is the most recent example. LTAT acquired more than 90% of Bauxite Plantation share as at 22nd December 2023. LTAT is so nice that they extended the closing date to 5th of January 2024 for the dissenting shareholder, who are those who haven't accepted the offer, to accept the offer. Let's say the offer closed at 5th of January 2024 with no more extension. And by the time you watch this video, it is already after the 5 market days before suspension. It is already after the extended closing date. Don't fret, it is not game over for you yet. There will be 2 potential scenarios. First scenario, under section 222 of CMSA, the offeror may compulsorily acquire any remaining share from the dissenting shareholders. In this scenario, it is easy. There's nothing you need to do. Your shares will be removed from your CDS and you will be compensated on the same term as the previous offer. This is the easy scenario. However, if the offeror does not invoke the section 222, it leads us to the second scenario. Second scenario, under 223 of CMSA, the minority shareholder may, within the offer period, which will not be less than 3 months, require the offerer to acquire their shares on terms of the takeover offer or other terms it may be agreed. At this stage, it might be your last chance to get out. So make sure that you have the right correspondence address registered to your CDS account and check your mail often. Why so primitive that you have to check your mail? Because by then the share might have already been delisted. So they will not necessarily make the announcement through the Bursa website. They are likely to communicate through the post. That's it for today's topic. Hopefully next time when you see a takeover offer, you will know what to do. I know that there's a limit to what we can do as retail investors. But here's the key takeaway. Don't give in so easily if you are not happy with the takeover price. Together we might stand a chance. As long as you keep track of the announcement, there will still be plenty of opportunities for you to get out if necessary. If you are still not sure about what to do with the takeover related to your shares, you can contact us through the Google link below. By the way, our top picks in the Market Highlight series beat the market big time last year. Let's keep this momentum going in this new year. If you like this video, do the usual, like, share, subscribe. Until next time.